How you doing, Mr. Fitch?
My name is Samuel Kamen. I represent SPOA, also some of the property owners in Southpointe. I would first want to reiterate the statements which Phil has made, Phil Bonanno and Colin. We've gone over the ordinance and we think that we're correct. I would like to address a couple comments. One, I've only been practicing for 53 years, but I don't think that you're acting in bad faith whenever you tell somebody they have to proceed, especially whenever they requested the date. Second, I'd like to address a different matter than my two previous colleagues have addressed, and that is section 402E, which is your standards for text or rezoning amendments. I agree with the chairman that what we're really looking for here is a change from residential category to commercial. And if you look at section E, which is the standards, and I'm not going to read them to you because I know you've been through them any number of times, the very first thing it says, the proposed amendment has to be consistent with the goals, objectives, and policies of the comprehensive plan as adopted and amended from time to time. That it has to be compatible with occurring conditions and the overall character of existing development in the immediate vicinity of the subject property. The proposed amendment has to be most desirable use for which the land in the subject property is adapted. The proposed amendment will not have an adverse effect on the value of the properties throughout the jurisdiction. And the proposed amendment reflects responsible standards for development and growth. Now, you've already received from Colin the initial comprehensive plan for Southpointe, where it says it's going to live, work, and play. You have the jewel of Western Pennsylvania and maybe the entire Eastern United States because of the mixed-use development which has been marketed and which has been so successful. In fact, it's so successful that they now want to try to change it and put a commercial use in the middle of the golf course. But that's not what was originally planned. That's not what the Redevelopment Authority thought about whenever they developed it. For that reason, I believe that you can take a look here in using these standards. You can deny the conditional use just on these information which has been provided to you today. And I might also add, because at the last hearing there was a statement there that we weren't going to address private rights, it's only the public rights. Colin has pointed out to you C5, which says you have to consider the redevelopment laws. The Redevelopment Authority has a veto power, and that is part of your ordinance. It's not separate and apart. And as a result, that becomes part of your ordinance. I thank you very much.
If I might briefly address these legal issues. First of all, with regards to Mr. Bonanno's citation, the proper section here is 913F2, which clearly says that it's applicable to proposed changes of the land use category of the developed lot. So that is, in fact, the proper section to proceed. So that is a clear misreading of the statute. With regards to Mr. Fitch's comments, the issue of the veto power is subject to, as he said, to litigation currently pending in the Court of Common Pleas. It is our position that that veto power expired in the covenants on space in 2010, but that is a wholly separate issue here, and there's nothing in the redevelopment laws of Pennsylvania that state that redevelopment authority has the veto power ad infinitum. So the issue is the interpretation of the covenants, and that's not something that's properly before you. Then lastly, I'd like to note that you're holding the record open for Mr. Fitch to submit materials. I don't understand why the applicant is not being entitled to its full 7 hours in making a presentation since you're already going to be holding the record open. Why can't we simply have it fully open and make our presentation? Finally, I would say that lastly, this August 1 date was not something that we requested. The extension was requested by the township. We did not want to have a 90-day extension as initially requested. The compromise was 45 days. August 1st was the date that was settled on by the township. It was not something that was requested by the applicant. And so I would just simply note that your refusal to let us put our presentation at another hearing within the 30 days is well within our rights under Section 908, and to deny us that is to deny our opportunities to make a presentation under the MPC. Thank you.
You know, we will leave the record open for you to submit your presentation that you might have given tonight that you didn't want to give us.
So we will be able to make a presentation.
The written record, we'll set some date, Chris, 20 days or something? The information, the brief on the information they didn't present tonight.
Then the objectors wouldn't have the opportunity.
And we have no problem with the objectors having an opportunity to respond as well. I think if you're going to hold the record open anyway, why not simply have another continued hearing so that all the information could be in front of you?
It's not
Can I ask
to
for
hold the record open.
We originally asked for a 90-day extension.
Yes.
You denied us.
No, we said we're in agreement to an extension. We had disagreements with some of the terms that were in the extension form that Mr. Volz did. There were some revisions of the request, and we agreed to a 45-day request.
But then you're asking.
It wouldn't be 90 days. And if we wanted to have a continued hearing, in another 2 weeks, that's fine as well too. But I just, we did not ask for August 1st to be the hearing date. And that's part of the fundamental misunderstanding, I think, that is going on here.
Chris, is that a misunderstanding?
Is not. Mr. Blumley states, Chris, as I stated earlier, everyone is just as
I don't think anybody lives here.
And I'm going to enter this email chain into evidence, but Mr. Blumley stated, Chris, as I stated earlier, everyone adjusted their schedules for August 1.
And again, I would submit you're holding the record open. We should be having an opportunity to submit materials and testimony on our behalf as provided under the MPC.
I believe Supervisor Cassiola meant that we are closing the evidentiary hearing, but if anybody would like to submit legal briefs, we will accept them.
Right, we want to set a time of.
But today is the evidence day.
Right.
And under the MPC, we're entitled to 7 hours of the hearing. And you're not providing us with the 7 hours. We've asked for another hearing.
We're offering it
Right now.
I just wanted to be clear, I did not ask the record to be held open. I merely responded to your request, Mr. Cassiola.
Well, so some of the information you gave us, though, it's kind of hard to digest without having the backing that you apparently think you have.
But I don't want the record held open. I'm not requesting that.
Okay, all right.
I will submit this email chain because it sounds like it's going to be an issue.
All right, excuse me, Mr. Cassiola. Mr. Smith has come and he's asked me if he could make a statement. I know I made one. He's a resident and he would like to make a statement
So
also.
we haven't closed the hearing yet. We didn't get to the citizens yet.
Oh, okay, I didn't know that she was...
Reading this email chain, what Mr. Volz didn't go on to read was, everyone adjusted their schedules for August 1. If that won't work now, can you schedule it for September 12th, being the first business Monday in September? There was nothing that said, oh, we have to have it by August 1st. This, on its very face, contemplated having a hearing in September. So I just like...
You can go through the email chain and it speaks for itself.
Go ahead, Mr. Smith.
Good evening. I'm Ron Smith. I've owned a company on One Champion Way since 1997 and part of the Southpointe Property Owners Association. I'm sorry, I don't have the legalese. Everybody speaking tonight is speaking the legalese. I'm speaking what has drawn me to the park. As everybody has said, it's one of the nicest parks in the United States, Southpointe 1. When I moved there, I did get a lawyer to look at the documents saying, hey, can they change the outlook? And we saw the veto rights and everything. As much as we looked at things, we felt we were safe. But I don't know the legal ramifications and everything, but I've been a good citizen there, and I can assure you, most of the people that have invested money there have done it on good faith, that it was going to be a place to live, work, and play. I feel this thing is going to be detrimental to that. I think changing it to commercial, it's called the Hope Learning Center. Well, it's been changed to commercial. If in a year the Hope Learning Center goes out of business, that is zoned commercial. So it can be used for anything that they basically want within that thing. So I just would like everybody to look at that. I think there's many different homes, many different types of condos, many types of apartments. There's a lot of people who invested there in good faith. And not knowing the legalese of all this, if something goes through, that they're going to develop this golf course, that's the biggest bait and switch in the history of Washington County, in the history of Cecil Township. They get you down there, you invested. A lot of people have $1 million homes. A lot of companies have $1 million businesses that they put there in good faith. And now you're going to change that. And like I say, I don't know all the legal things. That's why the lawyers are involved on both sides. I'm speaking as a person, as a concerned citizen, and as a good taxpayer to this township. Thank you.